Can I help you?
Yeah, we got a call about a suspicious vehicle in the area, and it matches this description.
What's suspicious?
He said you've been parked in front of his you were parked in front of his house for about an hour and a half.
Yeah? Is that suspicious?
Yeah, it's kind of strange. What's going on?
Nothing. Just sitting in my car.
Okay. You live here?
It doesn't matter. This is public.
Okay. You got your ID on you?
I'm not getting ID'd. I haven't committed a crime. Why would you need my ID?
Because this is a private this is a pretty quiet neighborhood.
Okay, is this a public place or a private place?
It is a public road, correct.
Thank you. Have I committed a crime by sitting here?
No.
Okay. Then I would not like to ID myself, because it's my right to not ID myself.
What is the issue here?
There is no issue. I'm over here minding my own business, sitting in my car, and you're coming up to me.
Correct, because I'm getting a call.
It doesn't matter if you get a call.
Welcome back, everybody. I'm a law enforcement trainer instructor. I train and instruct law enforcement and military all across the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigations, use of force, etc. And so what we're going to talk about today is we're going to talk about this reporting party, right? This I'm here investigating something because somebody called me scenario. And so as you can see in this video, it's clear the officer gets a call from a responding party. We call that RPs. And the RP has said, hey, there's somebody suspicious that is parked in front of my house. And the officer responds. The officer makes it very clear at the very beginning of this encounter that the person has not done anything illegal. They are parked legally on the public right-of-way, but the officer is still wanting to ID the person. And you can see, again, officers get stuck in this OODA loop, right? They get stuck in this OODA loop, and a lot of officers, again, people can chalk it up to whatever. I honestly believe it just comes down to bad training. Again, officers don't know what they don't know. Citizens don't know what they don't know. And let's be honest, nobody teaches the stuff that I teach here on this channel. This is definitely not taught at traditional police academies. This is not taught in college. This information is just not publicly taught. In order to receive this information, you really have to go to a very specific expertise type course. And so I'm wanting to change that. I think the more you know, the better. And so we're going to talk about what officers can and can't do. But again, it's clear this officer seems to think that because he is conducting an individual investigation, since he is taking time out of his precious day to conduct an investigation, he's taking his time out of his day to follow up, that somehow people are just supposed to fall in line with those directives that he's giving. And so that's just not the case. So we're going to talk about the case law on this, and we're going to talk about both reporting parties that are known and unknown, and we'll kind of hopefully get a better understanding. So to start off, like we start off with most of my videos, what does an officer need to detain and compel identification? Again, the Supreme Court is clear. The Supreme Court has affirmed law enforcement needs reasonable articulable suspicion of a crime in order to detain and compel someone to identify themselves. Brown v. Texas, 1979. Got that one out of the way. Now let's talk about responding parties, right? So let's talk about an anonymous caller. So as you can see here on your screen, we have Alabama v. White, 1990. The United States Supreme Court affirms that anonymous tip that can predict future conduct that the police can corroborate before a stop will satisfy the reasonable suspicion standard. The United States Supreme Court found that an anonymous caller who indicates that a woman named White could be seen leaving a specific address at a specific time in a specific vehicle in possession of a briefcase containing drugs. The anonymous caller further indicated that White would be going to a specific hotel with the drugs. The police conducted surveillance at the location to observe a White leave at the predicted time in the predicted vehicle. And then again, the court upheld after finding the anonymous tipster showed intimate knowledge of White. The caller's ability to predict White's future conduct found that was reasonable, that the officers did meet the reasonability standard for reasonable suspicion. So as you can see, this is more, okay, and we're going to go into some more case law. But this is more than just, hey, somebody's outside being weird. Somebody's being suspicious. That is not enough. That is not it. The Supreme Court is clear that's not enough. Supreme Court case precedence is clear. Circuit court case precedence is clear. State case law precedence is clear. Somebody saying something is suspicious does not give law enforcement carte blanche to seize that person, to detain that person, and compel them to provide identification. Let's look at another one. So another good one that I think is great to look at here. Narvet v. California, as you can see up here on your screen, anonymous tip and detentions. The Supreme Court has further clarified, this is in 2014, that police may make arrests or conduct temporary detentions based upon information provided by anonymous tip. The Narvet opinion cited 4 factors that bolster the reliability of an anonymous tip. Like we kind of already talked about in the previous case law, the anonymous caller personally saw the event. Hey, I'm witnessing this happen. 2, the caller immediately followed the incident. Hey, I watched this incident, and this incident just happened. 3, the call came in through the 911 system, which presumably has technology to trace caller identification, therefore deterring false reporting, because we know false reporting is a crime in many places. So the Supreme Court held that as a factor as well. And the 4th, the caller described an ongoing and dangerous crime. Narvet v. California, 2014. Again, we're talking about anonymous tips, anonymous caller. The next thing that we must understand, you've heard me talk about this before, the totality of circumstances. The totality of circumstances is defined as a method of analysis where decisions, whether that be reasonable articulable suspicion or probable cause, are based upon all available information rather than a bright line set of rules. Under the totality of circumstances test, courts found on all circumstances of a particular case rather than just one factor. Again, Illinois v. Gates, 1983, Maryland v. Pringle, 2003, Florida v. Harris, 2013, District of Columbia versus Wisby, 2018. Now, let's talk about if the informant is known or the RP is known, right? Whoever party is a known individual, right? The Supreme Court has affirmed that a policeman making a reasonable investigatory stop may conduct a limited protective search for concealed weapons when he has reason to believe the person, a suspect, is armed and dangerous. We know that again from Terry v. Ohio. The information from a reliable informant may also supply an officer with enough reasonable articulable suspicion for stop and frisk. Again, the United States Supreme Court recognizes that police officers making reasonable investigatory stops should not be denied the opportunity to protect themselves from an attack by a hostile suspect. Again, how reliable is your RP? Adams v. Williams, 1972. So in Adams v. Williams, as you can see here, the officer may have reasonable articulable suspicion just based upon a reliable informant, a known RP, and the reliability of that informant. Let me give you a really good example. So an example that especially small town cops can definitely relate with is let's say there's some kind of get together, right? Let's say you're at a football game or there's some kind of county event. There's an event where there's lots of people around, and let's say somebody is fighting, arguing, and somebody pushes somebody assaults somebody, and one of my RPs is the principal of the high school, or he's a pastor of a local church, or he's a business owner, whoever. Somebody that I have and can verify that they're reliable as a reliable RP, well, then I can make a detention based upon that person's information because this person has deemed themselves to be reliable in the past. Your off-duty cops, your off-duty firefighters. If I'm going to the county fair and I have a coach, our high school football coach comes up to me and is like, hey man, that person just punched that person in the face, and also just so you know, I saw that person had a concealed gun on him. Well, how do you know he had a concealed gun? Well, this coach has been a hunter his entire life. This coach carries concealed himself. This coach is an avid outdoorsman, avid gun enthusiast. He's a coach of the high school football team. He has a lot of rapport in the community. Yeah, that's somebody that I have a good enough relationship with where I would have no problem conducting an investigatory stop based upon his information that he's provided and his reliable, credible information. Again, I get it. Some people are not going to like that. Again, my job is not here to appease you. My job is just to give you the reality. And the reality is we have Supreme Court case precedents pursuant to in accordance with Adam v. Williams, 1972. From the Supreme Court, Court of Last Resort. So again, this is something that law enforcement can use in their tools, but they have to, again, they have to use this all reasonably, right? Just because you have an anonymous caller saying, hey, there's a guy at a park, he's walking around, and he's being a little weird, he has a camera, and he's going around, it's a little weird, it's suspicious, that's not enough to... There's no crime. What crime do you believe that he's committed? What reasonable articulable suspicion of a crime do you have? Now you get an RP that's like, hey, I saw this guy. I don't really know exactly. I don't know what exactly he's doing, but I can tell you that he's doing X, Y, and Z, and he can list out elements that would lead you to believe that there's a crime or criminality at foot, right? That would be something else, right? I don't know who this guy is, but he's at the park, and he's looking in cars. I've seen him wiggle cars, and he's going car to car, checking doors. Well, if I have a reliable RP that is reporting that, great. Let's say I don't have a reliable RP. Let's say I just have an anonymous caller. Well, then if I go to the park, and I go up there discreetly, and I see the individual doing what the RP is saying he's doing, well, there you go. I just develop my own, reasonable suspicion at that point. So again, there's ways to do this, and there's ways to conduct good, solid investigative work. But again, in this case, it's very clear this officer believes that just because he had a call and he is investigating himself and he's taking time out of his precious day to investigate, that people are just supposed to follow toe with every directive. That's not true. And at the end of the day, it's for police officers, this is very important. At the end of the day, man, yes, use your tools, use your resources, use your community policing, all that stuff. Voluntary compliance is great, but if you're going to encounter somebody and they just want nothing to do with you, you have one or two options. Either you can develop reasonable articulable suspicion, or you can't. And if you can't, there's one or two ways you can go about it. Or actually, there's really three ways you can go about it. You can violate their rights. Highly recommend you don't do that. You can ask for consent, or you can step off. You know what I mean? And so, again, that's where using your investigatory tools, Kansas v. Glover, People versus Bushley, using your inquiry methods, DMV, public records, the governmental interest venues of investigative tools that you have available. Use those. Use the resources that you have. But violating people's rights it's unacceptable. And so hopefully that helps you guys, and hopefully that helps the everyday citizen out there knowing the case law behind making contact for anonymous reporting parties and credible, verifiable, reliable responding parties. So I hope this was helpful for you guys. If you have questions, comments, concerns, please leave them in the comment section below. If you like this content, like, share, subscribe. As always, guys, long live the Republic.